Welcome everybody. I'm very pleased to be joined by Grant Incles today, who is a partner at Leigh. He's been working in the area of personal injury since 1999. So thanks very much for doing this, Grant. So Grant recently represented Ms. Charlotte Swift in her compensation claim after she suffered serious leg injuries in a road traffic accident in 2013. And that eventually led to the recent landmark decision in the Court of Appeal, which specifically was regarding how accommodation claims are settled. So Grant, could you tell us briefly, or just explain the ruling and how that applies to current and future claims?
Yeah, well, there's been a problem with the common law, so case law going back some decades. And it culminated in a case called Robertson and Johnstone, which was a 1989 Court of Appeal case, where the court tried to come up with a methodology to calculate how claimants should be awarded the increased costs of housing, the capital costs of that.
Yeah.
And the issue that they wanted to avoid was overcompensation. And only awarding 100% damages and nothing more. So what they found that they couldn't do is award the full capital cost, because if they do that, accommodation is the only future loss in a case like this that appreciates as opposed to depreciating. You know, just to take an example, for equipment, you know, wheelchairs depreciate, and therefore you have to change them every 5 years or so. Whereas accommodation increases in cost, or certainly was and has done over the last 50 years. So if you give them, the claimant, the full capital cost, that means that at the time the person disposes of the property, or usually when they die, their estate will recover what the court described as a windfall, and that's to be avoided.
Yeah. So
what they came up with a methodology, and I don't think I'll trouble your viewers too much with the ins and outs of that, because we could be here all day, but the methodology that they created led to a situation where claimants were awarded less than the full capital cost, because the court found that actually what you were doing, you were denying the claimant the opportunity of investing the capital sum. And so what they tried to do is work out, using a rate of investment, to work out what that money is worth in terms of investment over the years left of life, so that they are only left with the full amount at the time of death and not more than the capital sum. That's the brief summary of it. And so what was born was the Robertson-Johnson calculation, and it was never ideal because it always left a shortfall between the amount required to purchase the property and the amount that they were awarded. In 1989, the amount of the shortfall wasn't massive, but it still meant that claimants were having to borrow from other crucial parts of their damages claim to fund the difference. And what happened over the decades is property prices rose to the extent that claimants were having to borrow more and more from their damages, to the point where it was prejudicing their ability to make their damages award last for the rest of their lives. So it was never ideal, but then something happened in 2017. The Lord Chancellor, for some very good reasons, chose to reduce what we call the discount rate. And again, very briefly, discount rate is the rate by which we discount future losses, lump sums, to account for the fact the claimant is being given that lump sum early and has the opportunity to invest it. So it's discounted to account for that investment opportunity. Okay. What the Lord Chancellor did, the discount rate had been 2.5% for a long time, which was too high, and claimant practitioners and claimants were very vocal about that. The Lord Chancellor, Liz Truss at the time, reduced it to minus 0.75%. And that was fine for all other heads of loss, but in relation to Robertson-Johnson, the interaction between the methodology of Robertson-Johnson and a zero discount rate meant that the award for capital sum was less than zero.
Yeah, yeah.
So my client, Charlotte Swift, found herself in the very unhappy position of being only the second case that went to trial at first instance to look at this issue. The first case was JR and Sheffield NHS Trust. And the judge in that case awarded nil. The defendants very magnanimously agreed that they wouldn't take money off the claimant for it, and the award of nil was awarded, as was awarded in my case, or our case, of Charlotte Swift. Charlotte was awarded nothing at all.
Yeah.
So the implications of that were vast. Future claimants who need massive sums to buy the type of property they need as a result of their injury-related disability were going to get awarded nothing and have to borrow heavily from other heads of damage and go short. What this ruling has done in the Court of Appeal has corrected that, as far as the Court of Appeal found that they could. It is an excellent result. It's especially an excellent result in terms of long life expectancy claimants. Charlotte had a life expectancy which coincidentally is around the same as the average life expectancy that we understand is the average lifetime of a claimant, which is 43 years. Her life expectancy was around that. So she was a very good comparator for most claimants, and she recovered about 90% of the capital cost, which means the 10% shortfall was well within her pain and suffering and loss of immunity award, her general damages award, and so that she doesn't borrow anything from her future losses.
Yeah.
As a claimant practitioner, I was rather she didn't have to take anything at all.
Yeah.
But the court had to find a way of dealing with the shortfall, and they came up with something called, or they use an existing issue in trust law called a reversionary trust, by which to calculate what that windfall might be when the claimant died. So the implications for future claimants, certainly long life claimants, is excellent. It means that they have the confidence now to purchase accommodation, and that they will get, in a long life case, a very considerable percentage of that capital cost back and not have to borrow from really important heads of loss.
Yeah, fantastic.
Yeah.
So I'm just going to combine the next two questions, Grant, actually. So you've referred to them already, but how do you see the ruling impacting on accommodation decisions that clients can now make? And in particular, which I think is something quite relevant to case managers, does it make it easy for clients to move accommodation whilst their claim is ongoing before settlement?
Yeah, I think we need to talk about that in terms of two types of claimants, really. A long life expectancy claimant, firstly,
yeah,
and then a life expectancy claimant, which I'll explain a little bit afterwards. Long life expectancy claimants, yes, I think that we can be, as claimants and as claimant practitioners, we can be much more confident about making decisions about longer term accommodation at the start of the case. Of course, that's still subject to collating relevant evidence from whether it's a neurologist or orthopedic specialist, spinal cord injury expert. That still has to be there, and we still also have to think about care and case management expert reports before you can be absolutely sure about what the long-term accommodation needs are. But if you take an example of somebody who's lost a limb, an amputation case, which it's very clear in terms of what at the outset of a case you might expect the future to hold. I appreciate it's not so easy to do with a very significant brain injury case, or even spinal cord cases where the prognosis isn't terribly clear at the outset. But where there's a clear prognosis, I think that we can be much more confident. And case managers are faced, aren't they, with pressure from really both sides when they're talking about accommodation in their immediate needs assessment reports and thereafter. They know that their instructions will usually say, please don't think about long-term implications, please think about immediate need. But of course, what case managers are thinking is, well, you know, I'm trying to set up something here which sets the claimant up early, which provides that their long-term needs are perhaps in better shape. You know, so I think it's almost
impossible to ignore accommodation, you know, when you see it as an immediate need. Obviously it's a long-term issue to try and sort out for a case manager and a legal team, but it almost always, for very complex cases, is an immediate need.
Yeah, yeah. So you've got pressure from the defendant saying, well, we're not interested in that straight away. You've also got a certain amount of pressure from claimants, practitioners, understandably though, in my view, I would say that, to say that, well, hang on, you know, we don't know how much we're going to recover for the accommodation claim. So we've really got to make sure that we are maximising every other element of the case legitimately and carefully to ensure that if this claimant has to borrow a great deal of money from those other heads, they're not going to be as impacted as they might be if we can just wait and think about long-term accommodation towards the end of the claim when we've got all the evidence in place. Where, you know, that is a slight tension, and that's difficult for case managers, because what that claimant practitioner is usually saying is, well, so can you please look at rental options, temporary options, whether they're for 2 years or, you know, whatever that might be, a year or 2 years, usually 2, isn't it, by the time you've found somewhere and accommodate and adapted. And really, is that ideal for a family? I mean, if you think about a family in a short life case with a very damaged child who've got a short life expectancy, do you really want to spend half of that child's life in a temporary kind of setup that's not quite ideal but sufficient for purposes? Yeah. You know, there's a lot going on there and a lot to think about. And what I hope this does is allows a conversation to happen about long-term accommodation much earlier. Certainly life expectancy cases which have a long life expectancy. And when I say like a long life expectancy, you know, 90% was recovered in a 43-year life expectancy. Sort of 76, 80% might be recovered in a 30-year life expectancy. And the way that the calculation works, it goes down thereafter. With a short life expectancy case, I think that case managers would, and claimant practitioners now, even though we've got the Swift and Carpenter calculation, will still feel nervous about making early decisions because there is a battleground ahead in that regard. Once the judgment came down, and I think I tweeted something to say, yeah, it's great for us, but let's just be careful about short life and let's think about that carefully. Actually, the more and more I've read the judgment, and I've been back to it a few times now, the more I read the judgment, the more confident, the better I feel about short life expectancy, because I think the court has laid out very, very clear terms that if you're dealing with a short life expectancy case, let's say 7 years, where you might only have a 28% recovery under Swift, the court says two things. It says, the judgment, the Court of Appeal says, you are not straitjacketed as a claimant, as practitioners, by Swift and Carpenter in those cases. And where it looks as though Swift and Carpenter calculation will not provide fair and reasonable compensation, then overcompensation would be preferable. And so I think in short life cases, particularly in those very short life cases, say 7 years, I'm using 7 years because it was one of the paradigms that was used in the appeal, then I think there's a very, very strong argument, given what we've got in the judgment, to say that we should have full capital cost. That's our fallback position. Yeah. So I've banged on a bit, but to summarise, I think case managers, claimant practitioners should be thinking about earlier moves of accommodation where the circumstances do not lend themselves well to temporary setups. And it's up to claimant practitioners and defendant practitioners to work together to find an expert that they feel comfortable. You know, Jonathan France springs to mind, you know, but there are lots of really great architects out there. Yeah. To give a report early for both parties to work with, perhaps by a joint instruction. Really depends, doesn't it, on the expert and whether the parties are able to agree that. And think about rental and purchase at a much earlier stage.
And aside from that early communication and sort of getting that question of accommodation going early, any other practical implications for case managers in particular about how we can support clients to make sure that they do get suitable accommodation. Anything else aside from what you've just mentioned?
Yeah, sorry, battery's running out. Yes, I think that, I mean, you know, I'm a lawyer, so I wouldn't dare to kind of say that the very complex kind of processes that case managers have to think about in those early stages. But I think that evidence clearly is going to be the key, because there's still going to be nervousness from the lawyers about not having expert witness evidence. So just being really confident about the housing OT, or the OT generally, assistive, maybe even thinking about assistive technology issues earlier than we might. I mean, often there's nervousness around setting that sort of up in the case management because it will be rejected by the lawyers perhaps later. But just thinking about the experts that you've got on board, so an architect, if you can get agreement from the parties, a really good housing OT, and perhaps assistive technology if you're thinking about getting a longer term setup going.
Great. Well, that's fantastic, Grant. I won't keep you any longer. It's been great to, I know there's a lot in that, and we could talk a lot more about it, but I think that really nicely summarises which, you know, the word landmark is appropriate. So, you know, congratulations to you, but also congratulations for Charlotte as well. I'm sure she was really, really pleased with that judgment.
Yeah, she is. I'll just say one thing though. I mean, there's a lot of lovely congratulations going round. And that's great, and it was a wonderful result. But I think we all just need to be a bit careful about that, because for Charlotte, this is very much an ongoing issue. The respondents have appealed. We haven't got word from the Court of Appeal yet whether or not that permission is given to appeal. But certainly the respondent are making very strong arguments that this should be appealed up to the Supreme Court. And what that means is Charlotte won't have absolute, and the rest of us won't have absolute certainty about this outcome until either the Supreme Court, the Court of Appeal, have refused permission, or it's been to a hearing at the Supreme Court. And if it does go to a hearing at the Supreme Court, we could be talking many months hence. So it is a wonderful result and great news. But, you know, I just think about Charlotte watching this and thinking, well, it's not quite over for me yet. So
not quite over yet, yeah. And any ideas on a time frame as to a decision as to whether that goes further?
Yes, so the Court of Appeal said that they would deliver a decision on that after the 23rd of October. So we're a week after. Yeah, how much after, we don't know. You know, I won't be unprofessional and talk about what my thoughts are about the appeal, but I will just say this: the longer they take, perhaps that's the better for us, because it might be that they're being very careful about any rejection that they might make.
Yeah. Okay, well, thanks very much then, Grant.
Pleasure. Good to see you.
Cheers. Thanks, Grant.
Thanks. Bye.